Well, it seems to be going down, from future lockdowns to meltdowns to Supreme Court smackdown, which is now leading to a showdown. Let's talk on the mic. Hello, hello, good people. This is your guy, Mr. Educator, Mr. Communicator, Mr. Free Thinker, coming back at you live once again from the Lone Star State with another edition of the Media Mike Speaks. All right, good people, the time is 6 minutes past the hour, and yes, we are the voice of the everyday citizen. All right, good to be back. You know how YouTube is, so they had me on a 1 week suspension. So, some community guidelines things on the last video I did about, the sleepy Joe Biden. But anyway, that's neither here nor there, and so much for free speech. So anyway, let's get to this story, good people. As you know, the Supreme Court has been on a roll, but they're going to go on another roll. They're not done yet. They are just getting warmed up. So let's talk about this. In the U.S. Supreme Court decision, as we all know, on gun rights, religious liberty, and abortion, the next term, which begins in October, remember that month, could prove to be just as pivotal. It's going to be just as gruesome as this one, as people say, or surprising, I would say. So we have three cases here, good people. Number one, race and college admissions. That's who they're targeting next, the U.S. Supreme Court, that is. They have agreed to hear two cases involving the use of race in college admissions at the University of North Carolina and good old Harvard. Now, in both cases, which were consolidated by the High Court, a group called Students for Fair Admissions is seeking to overturn decades-old Supreme Court precedents that let universities consider race to help create a diverse student body. Oh, they're coming for it. In a 2003 decision, Greta v. Bollinger, the Supreme Court reaffirmed that universities can take race into account when determining admissions. In its appeals, the group called the Greta ruling immoral. Okay, immoral. I don't know if that's how that is compliance with the law, though. But we're going to get to that. In the Harvard case, Students Fair Admissions versus Harvard, the group is accusing the private university of favoring black and Hispanic applicants over Asian Americans, and in doing so, violating the Title VI of the Civil Rights Act. Now, they have a more case. These Carolina people are talking about immoral. Okay, we got to come better than that. In a statement, Harvard President Lawrence Bacow said the court's decision to review the case puts at risk 40 years of legal precedent granting colleges and universities the freedom and flexibility to create diverse campus communities, unquote. Considering race as one factor among many in admissions decisions produces a more diverse student body, which strengthens the learning environment for all, he said, another quote, unquote. Okay, I see his point. I do. But you got to look at actually what's right and what's fair here. And those students are really challenging that. Because if that school has certain admission standards and you don't meet it, then you need to go where you meet those standards. Now, in the North Carolina case, Students for Fair Admissions versus North Carolina, the group argues that the public university's consideration of race in its undergraduate admissions process violates the Title VI and the Constitution. Okay, now they're back on track. In a statement, the school said it considers race in admissions only if the student chooses to disclose it. Now, why wouldn't they do that if they know they can get in based on preferential treatment based on race? Why would they not? Now, some students don't, because sometimes it's based on a name. It is, just saying. Just throwing it out there. Now, let's get to the next case they're going to look at. Same-sex marriages. The court has also agreed to hear an appeal from a Colorado website designer who is refusing to create web pages for same-sex weddings because doing so would be odds with her faith. You know what? I can agree with that. I can. Because of those who are seeking to do that, same-sex, go to somebody who's going to do that for you. Don't force people to do something that is against their religious belief or faith. That's where they're landing in trouble. The same-sex people. You can't be forcing people to do something for you just because. Lori Smith, the owner of a graphic design firm called 303 Creative, is challenging a Colorado law that prohibits public businesses from discriminating against gay people. Now, this is what funny. This is what things are funny, good people. You can actually discriminate against people. See, this is what people don't understand. Now, it may say based off this, this, and this, but once a business owner says we have the right, the law states we have the right to refuse service based on people's behavior as such, or you get in there being unruly, or you come in dressed a certain way, you can say that's discrimination, which therefore you have a right to discriminate. Which you do. Businesses do. It says it. They have a right to refuse service to anyone. If you come in there ruly, you come in there with no shirt on, you come in there with lewd behavior, you come in there unappealing. That's why they say you have to come in here with a dinner jacket at some restaurants. You cannot come in here with your pants sagging. You cannot come in here wearing a hat. Isn't that discrimination? They have a right to do so. People need to wake up and understand how these things work. Anyway, let's continue. Last year, a federal appeals court ruled that while the creation of a website is protected as free speech, the state's anti-discrimination law does not violate the Constitution because it is designed to ensure that LGBTQ customers have access to wedding-related services of the same quality and nature that Smith provides. But still, we have a problem here. Go to somebody who gives you that service, because this is going to get overturned. I'll tell you that right now. The case 303 Creative LLC versus Elenis is strikingly similar to the one in 2018 involving a Colorado baker who refused to make cakes for gay weddings. In that case, the court narrowly ruled in favor of the baker, Jack Phillips, but declined to rule whether compelling him to bake a cake for a same-sex couple will violate his right to freedom of speech. Well, it did. I can tell you right now. Once the court ruled in his favor, the people need to go somewhere else. Go somewhere else where somebody will do that for you. Let the same-sex people have their own bakery. What is the problem with that? This is about to get messy. I don't know where this is going, but it's about to get real messy. Now, last, election laws. The Supreme Court announced Thursday that it has agreed to hear a case that some legal experts fear could upend election laws across the country. The case, Moore v. Harper, involves newly drawn maps of voting districts for North Carolina's 14 seats in the U.S. House of Representatives. In February, the maps were struck down by the North Carolina Supreme Court, which concluded that they relied on redistricting criteria of extreme partisan advantage for the Republican Party. The Republican-controlled legislature is seeking to reinstate the gerrymandered maps, arguing that the state's highest court had no right to block them. Now, if this is true, they're going to redistrict those lines, because if they say that the states has control of the Supreme Court was out of order. The appeal to the Supreme Court is based on independent state legislative doctrine, a fringe legal theory that contends state legislators should have the power to determine how elections are run without any checks and balances from state constitutions or state courts. As SCOTUS blog notes, proponents of the theory point to the Constitution's Elections Clause, which gives state legislators the power to set the times, places, and manner of holding elections for senators and representatives, unquote. The nation's highest court has historically deferred to state courts on how state election laws should be interpreted. In previous opinions, conservative Justices Clarence Thomas, Samuel Alito, Neil Gorsuch, and Brett Kavanaugh have signaled a willingness to reconsider it. Endorsing the independent state legislature theory would be a radical departure from the established precedent and could trigger even more legal chaos for future federal elections. So, according to the 10th Amendment of the U.S. Constitution, if the states, the separation of federal and state, if the states has the power to do this, the Supreme Court's out of order. They're going to look at it, and here we are. So that could be overturned, and the Republicans could redistrict those lines, and here we are. I do believe they're going to win come November, but unless the Democrats pull a rabbit out of the hat, which I'm thinking they're trying to do. So, and now a word from those who commented. You know what? I may do a stream on this. I'm probably going to do a live stream. I'm going to have to do that on this, because this is something else. Now, from those who commented, one commenter states, wait for it. They are signaling for more challenges from businesses about regulations. If the EPA can't regulate the environment, then OSHA shouldn't be able to regulate safe working environments, and HHS shouldn't be able to regulate about the public health. Those seeing these signals should start lining up challenges at your local courts to start the process working through the system while you have a very business-friendly SCOTUS, Supreme Court of the United States. Okay. One other comment is stated, the agencies you cite should be able to regulate the areas in their mandate, but only as far as enabling legislation allows. The Supreme Court is saying that if additional regulation is needed, it must be authorized by the Congress, whose members are elected, not the agency, whose members are not elected. Clearly, the Supreme Court's decisions are turning to the law as currently written. If we want changes, we should petition our elected officials, not our unelected officials. Good point. Another comment added, disaster if you know anything about how Congress currently functions. It does not. That's funny. Another comment is stated, it is a disaster when we allow the unelected to do things beyond their mandate. True. I agree. Well, good people, until next time, this is your guy, Mr. Educator, Mr. Communicator, Mr. Free Thinker. Subscribe, share, and like to keep me rocking on the mic. Have a good night.
Understand you soon, it won't be long. Keep on, keep running.